Let's talk severance agreements. A severance agreement is a legal document between an employer and employee that outlines the terms of the employee's separation from the company. A severance agreement is often offered to employees who are terminated or laid off. Some are surprised to know that even employees who choose to resign from their position might be offered and can even ask for severance if it is not offered. Whatever the reason for separation, the severance agreement is a legally binding document, usually designed to protect the interests of the company and thus should not be signed without consulting an attorney first. When presented with a severance agreement, it's up to you to protect your own interest by knowing your rights and negotiating the best possible severance package. As such, it is strongly advised that you have an attorney review any severance agreement presented to you so the attorney can explain the terms and conditions of the proposed agreement and advise you of your rights. The attorney will likely ask you to share with them the circumstances that led up to your separation. Typical terms of a severance agreement will include the company giving you a set amount of money in exchange for your agreement not to pursue claims such as wage and hour claims, discrimination claims, sexual harassment claims, and more against the employer in the future. The agreement will likely have other clauses that are geared to protect the employer but may hurt you. Clauses like non-compete, non-solicitation, non-disparagement, or non-disclosure clauses that prohibit you from speaking about the illegal acts of the employer after you sign the agreement. An employee must be given sufficient time to have an attorney review the agreement and advise them of their rights. Many of these clauses may be written in a way that is unfavorable to you or are downright illegal. That is why it is important to exercise your right to have an attorney review the agreement before you sign. Your attorney will ask that you share details of what led to your separation from the company. If these details lead the employer to believe that you may have been wrongfully terminated, forced to resign, or the employer did not follow laws related to a layoff, your attorney may advise you not to sign the agreement. Likewise, if the circumstances leading up to your separation uncover concerns of sexual harassment, discrimination, unsafe working conditions, failure to properly pay wages, retaliation, or other violations of the law, the attorney will likely recommend that you don't sign the agreement as is. Instead, the attorney may advise that the agreement be negotiated to be in line with the value of the claims you are giving up and include terms that are more favorable to you while removing terms that may be illegal or worded in favor of the employer. Your attorney can negotiate on your behalf to increase the monetary offer and make sure you receive the best possible package. Your attorney can communicate directly with your former employer and their attorneys on your behalf to advocate for new terms and non-monetary benefits, such as continued health benefits, retraining, or help finding a new job, keeping equipment, or sometimes even terms regarding stock options. If you were not offered a severance agreement by your employer, your attorney can ask for one on your behalf and work with your employer and their attorneys to draw up fair terms that are in your best interest. EJP would be happy to review your severance agreement, demand severance if it was not offered, educate and advise you of your rights, and advocate on your behalf. This is just a brief overview of your rights. For more information or for help with the severance package, reach out to EJP. We may be able to help.